The Supreme Court is unlike any of the other branches of government because they don't have any real way to enforce their decisions other than the fact that we believe their decisions are legitimate. So if you have a court where a third of the justices have emotional support billionaires and are receiving largesse from corporate interests, then it makes it look to the public like maybe some of these decisions aren't necessarily based in law. Maybe they're influenced by other things. When you have conservative groups angling to get face time with justices by buying buildings across from the Supreme Court, maybe it makes it look like some of these Supreme Court rulings aren't necessarily about the law, but are about other things. And so the court's loss of legitimacy among the public is part of that whole demimonde at this point. Everyone is talking about the fact that the court, now with a 6-3 conservative supermajority, is issuing conservative decisions one after one, changing the law, overruling precedent, while all being in the pocket, it seems, of these different interests. And I think that's what's contributing to this loss of legitimacy.
So, Ellie, the emotional support billionaires is definitely the kind of thing we weren't thinking about in the past. Tell me how a court that is supposed to not sort of sway with the winds of political opinion in the immediate moment, how it's supposed to navigate the idea that we may be making decisions you don't like, but we're legitimate. And if the court can't do that, what else can be done fairly immediately to try and restore faith in the court?
Yeah, I guess I disagree with the premise of your question, Allie. I don't think faith should be restored in this Supreme Court. This Supreme Court already has too much power. We should not like them. Look, people think that you need to get like 270 electoral votes to win the presidency, but in fact, you need to get 270 electoral votes and 5 Supreme Court justices, because they have more control over the election than voters in, say, California or New York, right? And so it's that kind of power that they have accrued to themselves that needs to be taken away. And as long as we keep acting like the Supreme Court is supposed to be kind of above the law, kind of apolitical, kind of all these other things, then we don't get down into the dirt about what they actually do for a living. The same institution that once ruled a black person like me has no rights that the white man is bound to respect has now ruled that a pregnant woman has no rights that Donald Trump is bound to respect. Like, that's a problem. We should be angry at their decisions. We shouldn't trust their judgments. And we should be doing everything we can to have the elected branches of government, Congress and the president, the people that we vote for, control our most important decisions, as opposed to 9 unelected, unaccountable judges who operate above the law.
All right, so I want to perhaps come back to this conversation about the Supreme Court itself. But in the meantime, I want to get to some of the things that are on the docket right now, because for the moment, this is the Supreme Court we've got, and they're going to be looking at these issues. Melissa, the case about gender-affirming care has resonance beyond health care. States like Alabama already limit the ability of transgender people to change their driver's license, for instance. Give me a sense of the impact on trans rights and on rights more broadly of gender-affirming care.
Well, let's just say at the outset, Ali, that this is already shaping up to be a pretty consequential term, with cases like the case that you just mentioned involving gender-affirming care for minors being on the docket. And we have just gotten started. This time last year, the court hadn't taken the challenge to the EMTALA case, the abortion across state lines. It hadn't taken the mifepristone case. It didn't have the Trump disqualification case or the Trump immunity case on the docket. So all of this could turn on a dime, and this could be even more consequential a term than we're already anticipating. But this case, United States versus Skermeti out of Tennessee, is hugely important because the court has granted certiorari on an equal protection issue involving sex-based discrimination. The argument is that these laws that prohibit gender-affirming care to minors discriminate on the basis of sex. So this is the 6-3 conservative supermajority's first case that would allow it to take on the equal protection clause in the context of sex-based discrimination. Justice Ginsburg, who used to be the most stalwart member of the court, who had a robust view of the equal protection clause as a bulwark against sex-based discrimination, is no longer on the court. So we're really going to see what this conservative supermajority has to do with sex-based discrimination, and that could have real consequences for abortion and other kinds of discrimination down the line.
Ellie, next week the court's going to hear a death penalty case. It involves a potential constitutional violation after prosecutors withheld key evidence. It's a fact that the Oklahoma Attorney General has actually acknowledged. The Supreme Court has generally, historically avoided intervening in state, not federal, execution cases. Tell me a little about this one.
No, this Supreme Court likes to kill people. This Supreme Court has been on a heater, Ali, where it is trying to get as many people put to death as quickly as possible. And when they rule to put people to death, the 6 conservatives seem annoyed, literally annoyed that people dared to ask them to save their lives. The particular case at issue this term involves a man named Richard Glossip. The Supreme Court has literally tried to kill this man before. He came up to the Supreme Court earlier, almost a decade ago, arguing that his death penalty conviction violated the cruel and unusual punishment clause of the Constitution. And Samuel Alito, who was on the court at that time, John Roberts and Clarence Thomas, who were on the court at that time, said, no, go off and die. All right. Well, Oklahoma actually paused its executions. That gave Glossip an opportunity to gather new evidence. He has evidence that likely exculpates him from his alleged crime. He's accused of murder. The person who actually murdered the victim, that testimony has been called into question. And so now he's coming back to the court asking to throw away his conviction. So it's not even technically a death penalty case. It is trying to get a new trial based on new evidence this man, who the fact that he's alive is a miracle, has been able to bring forth. And the Supreme Court might just try to kill him again. That's what these conservative justices do.
I remind people last week a man who was broadly thought to be innocent of his crimes was put to death. Melissa, the case involving Mexico suing gun manufacturers in the United States is interesting because the gun industry generally enjoys broad legal protection in the United States. But Mexico claims that about 70% of trafficked weapons come from the United States. The gun industry is accusing Mexico of trying to bully them into adopting gun control. What should we be thinking about with this case?
Well, the court just granted cert on this case on Friday. So again, things can change on a dime here, but I'm not really optimistic for Mexico's chances here. So basically, this is a complicity theory. Mexico is arguing that Smith & Wesson, who is the gun manufacturer here, is complicit in the drug cartel violence because they allow the drug cartels to smuggle firearms into the country unlawfully without subscribing to the rules that Mexico has set out. One, this is a court that takes a pretty broad view of foreign sovereign immunity. Again, also a very broad view of corporate liability and immunity. I'm not really optimistic about Mexico's chances, also because this court is one that takes a very broad view of the Second Amendment. But this is certainly a case to watch and one that gun manufacturers are going to be watching with great interest because so much could depend on this case.
Ellie, and then there's the other issue about these ghost guns. To me, this doesn't seem complicated, right? If you can buy something that can easily become a gun with very little effort in a few minutes, it probably should be treated the way you treat a gun. But there are folks, including the Fifth Circuit, who disagree with that.
Yeah. First, before I get to ghost guns, I can't resist the plug. I have an upcoming book, and it deals specifically with the law at issue in the Mexico case.
Oh, okay.
It's a law that shields U.S. gun manufacturers from any legal liability, and no other industry in the country has it. That's the law that they're trying to pierce. And as Professor Murray accurately says, the Second Amendment amosexual conservatives will not let that law be pierced. So putting that to the side.
Very good.
The ghost gun case, to me, is very simple, right? If you buy a gun that's already assembled, it comes with a serial number so that we can track the gun if it gets stolen, if it's used in a crime. It's kind of a basic regulation on guns, right? If you buy a gun that is disassembled and you put it together yourself, that doesn't include a serial number. And so it's a way to evade almost every gun law we have on the books, right? And so people need to understand how these things work. Like if you go to the online, you go to the dark web, you go to some places, you can find everything you need to make a bomb online, right? You can go to the Home Depot or the Lowe's and you can buy most of the stuff that you need to make, an incendiary device. If Home Depot had a section, build better bombs here, that would be a legal problem, right? If Lowe's sent you all the bomb-making components to your house with the instructions, that would be a problem I think most people would have. Well, that's what ghost gun manufacturers do. They send you all the parts you need to make the gun. They send you the instructions to it. All you need to do is put it together. Yet that has no serial number, it has no tracking, it has no way to, it's a way for people who really, really shouldn't have a weapon to circumvent what few gun laws we have. And again, the amosexuals on the Supreme Court are likely to say that this is okay over the objection of liberals and people who like to be alive.
That second part's important. Melissa, you previously clerked for Justice Sotomayor, whom you heard expressing deep frustration with things that have been going on in the Supreme Court. And this drop in public trust is remarkable. I want to, is there something, I mean, I know Ellie has said this may be irredeemable, but we have 19 now and possibly 28 cases on the docket in the next year. What do we do?
Well, I think we vote. I was in the audience when Justice Sotomayor made that startling statement back in May. None of this changes unless you get a new administration. And to be very clear, simply getting a new president and a new Senate doesn't change the composition of this court. I mean, you have to wait for one of these justices in the conservative bloc to leave the court and to be replaced by someone who's nominated by a Democratic president for the ideological balance to shift. But make no mistake about it, if a Republican wins the presidency and the Senate remains in the sort of fractured position it's in now, or the Republicans take control of that chamber, then you will have Sam Alito and Justice Thomas, who are both septuagenarians, stepping down, and they will be replaced by movement conservatives who are likely to be teenagers or slightly older, and they will remain on the court for the next 50 years. So if you are concerned about this court, if you would like to see more wide-ranging efforts to bring this court back into line, to strip it of some of the power that it has arrogated to itself over the last couple of years through its decisions, then you have to really think seriously about who you're voting for all the way down the ballot, and you have to make your voice heard, and you have to stay in it. This is not going to be an instantaneous change. This was a 50-year campaign to capture the court and get this conservative supermajority in place. It's going to take a lot of time to undo that, and American voters have to be prepared for a marathon, not a sprint.